Welcome to Protected Thoughts. I am Mary Lise Paul, and I'm here with my co-host Bruce Paul.
Good evening.
We are back in the recording studio today, recording an somewhat emergency podcast to discuss the Supreme Court decision issued on Thursday, May 9th, 2024, which will be, at least for the foreseeable future, a big-time damages case in the world of copyright law. And that case is Warner Chappell Music, Inc. v. Nealy. Bruce, what do you want to tell us about the decision?
Well, just to set the stage, the case started in the Southern District of Florida. Sherman Nealy was a musician, and he created a record label in the 80s and created a few singles and a record with a few artists, the main one being a fellow by the name of Pretty Tony, which is Tony Butler. I've read that Tony Butler was the talent and Sherman Nealy was the money person. And they created this record together. Nealy then went to prison for several years for drug charges, was released, went back to prison for several more years for drug charges, and then got out and claims that he discovered several of those songs he created in the 80s had been licensed by Warner Chappell, Atlantic Records, some other defendants, to talents that you've probably heard of. I
What
believe
songs are
Pitbull.
these? Do we know these songs?
I do not know these songs, but I know you know these songs. These are right in your wheelhouse.
Mm-hmm.
One is In the Air by
Flo Rida.
Flo Rida.
I'm very familiar with the song, yes.
Well, interestingly, as a side note, most of the stories that I've read on this case, and in fact the Supreme Court case itself, cites that the case is called the song that Nealy and Butler did in the 80s was called In the Jam, was used by Flo Rida in his song In the Air. But in fact, the district court found that Nealy didn't have any standing to sue for that claim. So that was the kind of the sexy song of this case. It's the one that probably grabbed the attention, but it's probably not even at issue in this case. It just made a good headlining.
When I looked on Spotify to see if we could find the original Nealy and Butler songs from the 80s, I wasn't able to find any of the originals. How about you?
I didn't, and per your encouragement, I did, however, listen to In the Air and the Black Eyed Peas and the Pitbull songs that use these tunes, and at a loss, don't know any of them.
What are the Black Eyed Peas and the Pitbull songs?
The Pitbull song is called Fuego, and it sampled apparently a song by Nealy or by his group of musicians called When I Hear Music. And the Black Eyed Peas song was called Weekends, which used apparently Lookout Weekend.
Now, will.i.am is actually featured in the Flo Rida In the Air song and also a member of the Black Eyed Peas. A little fun fact for you there.
Not perfectly familiar with how this works, but if all of them are either Atlantic or Warner artists, that would make sense. So anyway, Sherman filed suit in the late teens for these songs that he found out had been stolen, according to him. And the Warner Chappell filed a motion to dismiss in the Southern District of Florida on all of the claims, leveled a bunch of grounds for dismissal, statute of limitations, as well as standing, and claiming that actually Nealy didn't own the music. Tony Butler owned the music since he co-wrote it, and he had granted them licenses. The parties filed cross motions for summary judgment at the district court level, and the court granted some of the motions in part, denied some of the motions in part, and ultimately decided that the statute of limitations did not prevent Nealy from filing suit on some of the songs, but there was a statute of limitations on damages so that he could only go back 3 years and collect damages. And that was stuck in a footnote of that. It was actually a magistrate's report and recommendation, and then the district court affirmed that report and recommendation. Because a 3-year look back for damages would render a lot of the value of the case moot, the parties sought interlocutory appeal on that issue in the summary judgment. The district court granted that interlocutory review. The 11th Circuit accepted interlocutory review, and the 11th Circuit reversed on that issue. The 11th Circuit determined that so long as the claim by Nealy was timely, he could recover damages going all the way back to the mid-2000s when those songs were sampled and the losses were suffered. So after the 11th Circuit reversed, a circuit split existed. The 11th Circuit went along with the 9th Circuit, which had held that you could go back beyond those 3 years. And the 2nd Circuit had found that there was no 3-year, or they were stuck with the 3 years of damages even if they could file suit. So that is what the Supreme Court looked at.
So the Supreme Court decision is really about whether there's a time limitation on damages in a copyright case. Justice Kagan delivered the opinion of the court, in which Justices Roberts, Sotomayor, Kavanaugh, Barrett, and Jackson joined. Justice Gorsuch filed a hot dissenting opinion, in which Justices Thomas and Alito joined. What isn't decided in this case, and what the dissent of the case is really about, and perhaps is very interesting, is whether or not there is room for the discovery rule in a copyright case. So, Bruce, you've mentioned a couple times that the court assumes that the claims were timely brought under the Copyright Act. And this assumption is raised both in the 11th Circuit and repeatedly in the Supreme Court decision. So under the Copyright Act, a plaintiff must file suit within 3 years after the claim accrued. The court talks about how, on one understanding of that limitations provision, a copyright claim accrues when an infringement act occurs, and that means that a plaintiff can complain about infringements going back only 3 years from the time he filed suit. And the court notes that if that rule governed, many of Nealy's claims would be untimely because the alleged infringements occurred as many as 10 years earlier. However, there's an alternative view of the Copyright Act's limitations provisions, and that is that a claim accrues when the plaintiff discovers or with due diligence should have discovered the infringing act. And that's what we're talking about here when we say the discovery rule. And the discovery rule is used in the 11th Circuit, which is where Nealy brought suit. This discovery rule enables a diligent plaintiff to raise claims about even really old infringements if he discovered them within the prior 3 years, which is what Nealy did here. So Nealy, as you commented, Bruce, discovered these infringements of his songs when he came out of jail, and so then brought suit based on Warner Chappell's infringing conduct in 2016, which is right after he got out of prison and less than 3 years before he sued. So the court, in the opinion, talks about how Warner Chappell accepted that the discovery rule governed the timeliness of Nealy's claims for some reason, but it argued that even if Nealy could sue under the rule for infringements going back 10 years, he could recover damages or profits only for those occurring the last 3. Now, there seems to be, in my opinion, an inconsistency with saying that the court should not have decided the discovery rule here, but also suggesting it maybe should be deciding the discovery rule. What do you think about that, Bruce?
It's kind of an interesting dilemma for lawyers in this situation because it appears that I know that it's been a given in my experience that the discovery rule has been applied to the Copyright Act, which is to say, if an image is online and it's been online for longer than 3 years, but you as a plaintiff who alleges to own that image claims that you didn't see it before a period of time within 3 years, then you would be saved from filing that infringement claim. And honestly, I've had cases in the Second Circuit. I've had cases in the Ninth Circuit. I've had the cases in the Seventh Circuit, and it's never been an issue. And in fact, there are allusions to the fact that there isn't a circuit split on that. Courts have universally applied that from circuit to circuit. But what there was a circuit split on was the how far back could you get damages if it was timely brought. And honestly, I feel bad. I mean, the Supreme Court makes a big deal about how the parties just took it for granted that that the discovery rule applied. But, we're taught as lawyers that if the Supreme Court hasn't spoken on something, you look to the circuit, and you're bound by the circuit because that's binding precedent. So it would be bold for a lawyer and for a party to make the claim that the discovery rule doesn't apply in the 11th Circuit if there's clear precedent that tells the parties that the discovery rule does apply.
Well, but the opinion drops a footnote that talks about how Warner Chappell's briefing before the Supreme Court focuses almost entirely on the discovery rule. So it seems like there is briefing on the discovery rule, but that the question on cert is whether the discovery accrual rule applied by the circuit courts, or under that rule, a copyright plaintiff can recover damages for acts that allegedly occurred more than 3 years before the filing suit. Again, not whether the discovery rule applies. So the court says that you can't change what the rule is on cert, but also makes a big deal about noting that the question before them incorporates the assumption that the discovery rule governs timeliness of copyright claims, and that the Supreme Court has never decided that this assumption is valid. So again, meaning the Supreme Court's never decided whether a copyright claim accrues when a plaintiff discovers or should have discovered an infringement rather than when the infringement happened, and that the review is only confined to the damages issue.
Right. Well, that footnote 1 that you're referencing in the Supreme Court ruling in Justice Kagan's majority opinion, it scolds Warner Chappell a little bit, because Warner Chappell appears to have sought cert on the damages issue. It appears that perhaps Warner issue plugged in a footnote in that motion for cert, alluding to or questioning the statute of limitations itself and whether or not there was a discovery rule inferred in the Copyright Act statute of limitations. But because they didn't genuinely argue it below, it wasn't ripe for review. They couldn't they couldn't truly raise it. And so once the court granted cert and formulated its own question for the parties to brief, Warner Chappell was kind of stuck with that issue. And
As is the court.
I'm sorry?
As is the court.
Well, yeah. As is the majority of the court. There are 3 justices that disagree with that. But Warner Chappell apparently, well, I mean, the footnote starts disregarding the limit of the formulated opinion. Warner Chappell's briefing in this court focuses almost entirely on the discovery rule itself. So Warner Chappell probably went down the line, and I can just imagine what the lawyers were thinking, kicking themselves, perhaps thinking, "Oh my gosh, have we blown an opportunity to discuss and destroy the discovery rule in the Copyright Act?" And so they were just trying to shoehorn it in. And, to their credit, they caught fire from the majority, but they had three
Mm-hmm.
justices, I'm sorry, on board.
Well, and even in the majority opinion, it seems to leave room for the fact that the discovery rule may not apply. This is just not the case to be deciding it. The majority opinion cites to Petrella v. Metro Goldwyn Mayer, Inc., a 2014 Supreme Court case for that initial reading of the interpretation of when a claim accrues, and that is, no civil action shall be maintained under the provisions of this title unless it is commenced within 3 years after the claim accrued. So that case could be read to leave out the discovery rule.
The Petrella case was in and of itself an interesting case. It's kind of the cool things about copyright law as a side. You get to deal with cases and properties and movies and music that you've heard of. The Petrella case involved the famous movie Raging Bull, which was a boxing movie featuring the life of Ray LaMotta. And LaMotta's childhood friend their lifelong friend was a fellow by the name of Petrella. Petrella's daughter inherited Petrella's copyrights in the screenplay that became the movie, and she knew that MGM was going for the movie, was making the movie, and was exploiting the movie, is the word that they use in the copyright world. And she just didn't file suit, but because a rule of copyright law is the statute of limitations can run from each injury, each time MGM exploited Raging Bull again, that renewed the statute of limitations. So she was only going back 3 years because she had let the case, or she had let them use it for 18 years. And she knew she couldn't go back, so her claim was filed timely for the most recent exploitation of Raging Bull, and she was only seeking damages going back 3 years, which is why some of the language of Petrella led the Second Circuit and the district court in the Nealy case to find that damages only went back 3 years.
There's an interesting line in that decision. It says a successful plaintiff can gain retrospective relief only 3 years back from the time of suit. No recovery may be had for infringement in earlier years. Profits in those years remain the defendant's to keep.
Right, and that's the Petrella language that captured the attention of the Second Circuit in creating the circuit split there, and then that's the language that captured the attention of the district court in the Nealy case. But as Justice Kagan explains in her decision, that was language that was applicable to the facts of the Petrella case, not a statement of law more generally. So when you read Justice Gorsuch's dissent, it's a fun little reminder that judges have rules. They have the Supreme Court has rules of formulating a issue on cert and what to decide and what they're bound by, but they can write what they want. And Justice Gorsuch he acknowledges that because of the formulation of the issue on review, the court was stuck considering the damages question. But he properly notes that they're kind of wasting their time, because I don't know that there are 5 votes to keep the discovery rule under the Copyright Act. And in fact, we're, 20 minutes into this podcast, and we've kind of buried the lead, because that's really perhaps the bigger takeaway from this case, is that although this damages issue is an important one, and one that's going to embolden plaintiffs in copyright claims to use the discovery rule and then go all the way back as far as they can for damages, the reality is every defendant in one of these cases that sees an alleged infringement that is more than 3 years old is going to make the argument that it's dead law. They're going to take it through the circuit court, wherever they're litigating, and they're going to try and go to the Supreme Court, because it honestly appears that the statute of limitations does not use a discovery rule.
The foundation of Gorsuch's dissenting opinion really is the Porchella case, for the notion that the statute of limitations period begins to run when the plaintiff files suit and can obtain relief. So quoting from the case, he says, quote, ordinarily, a claim, quote, accrues when a plaintiff has a complete and present cause of action, end quote. And the way that they talk about the discovery rule is that it is, quote, not applicable across all contexts, end quote. And that is citing to a different Supreme Court case, TRW Inc. v. Andrews. The dissenting opinion limits the discovery rule to say that it's not applicable across all contexts. So they limit the discovery rule to only apply in cases of fraud and concealment. And the dissenting opinion notes that they've warned lower courts from taking the expansive approach to the discovery rule, and yet lower courts have applied the discovery rule across all contexts. So, Bruce, I think that you're right that going forward, if you had a party that was willing to take this discovery rule all the way up to the Supreme Court just might find there is no room for the discovery rule except in the context of fraud or concealment, as the dissenting opinion writes. But again, the Warner Chappell Nealy case was not the proper case to be deciding whether the discovery rule applied in the context of copyright law broadly.
I agree, Mary Elise. And to put a finer point on it, when I say that, I think, well, we can quote Justice Gorsuch's own opinion. At the end, he says, and in this language at the end of the dissent is in acknowledging that because the issue before the Supreme Court is damages and not the discovery rule, he acknowledges that they might be coloring outside of the lines by even discussing the discovery rule. But his language is pretty sharp. It says, quote, "Nothing requires us to play along with these particular parties," being Nealy and Warner Chappell, "and expound on the details of a rule of law that they may assume but very likely does not exist. Respectfully, rather than devote our time to this case, I would have dismissed it and awaited another squarely presenting the question whether the Copyright Act authorizes the discovery rule. Better, in my view, to answer a question that does matter than one that almost certainly does not." And so he's signaling that give us a case, or he's instructing parties to give the Supreme Court a case that asks whether or not the discovery rule exists, and you're going to find that probably it does not. one other observation I would make, which I think might be why Justice Gorsuch is so bold in making that prediction or suggesting that would be the result, is the two cases that Mary Lise you just referenced, Petrella and the TRW versus Andrews case, were both written by Ruth Bader Ginsburg.
Yeah.
And the Petrella case that pretty matter-of-factly states the statute of limitations is 3 years from when the infringement occurs, was written by Ruth Bader Ginsburg. And similarly, in the TRW case versus Andrews, that was not a copyright case. That was a FCRA, Fair Credit Reporting Act case. But again, her language in that case is pretty matter of fact that if the statute at issue does not specifically create a discovery rule for a statute of limitations, then courts ought not be reading a discovery rule into those statutes of limitations. So if that is who is generally considered to be a liberal justice writing both of those opinions, Alito and Thomas and Gorsuch are considered to be three of the most conservative justices on the present court, then I think it's fair to assume that there can be enough votes to get rid of the discovery rule under the Copyright Act.
So I think we have two takeaways from this Warner Chappell Music Inc. v. Nealy case right now. And the first is that from the case opinion, if claims are timely brought under the Act's, Copyright Act's, limitations provisions, then damages may be obtained for them. And the second is, it remains to be seen in the future if the discovery rule will apply in a copyright case if the right case is brought before the Supreme Court to decide that discovery rule.
That's right, Mary Lise. I think the lesson here is plaintiffs need to be even more proactive in looking for infringement and prosecuting infringement in a 3-year timely manner. And defendants have a new affirmative defense to more aggressively pursue, because even though these circuits have held that the discovery rule allows a plaintiff to bring a case after 3 years if they claim to have only then found something, there's a great big invitation from the Supreme Court to ignore that circuit court precedent.
I agree.
Well, I think that's it.
Thank you for tuning in. Remember, we are lawyers, but we are not your lawyers. But we love talking about the law. We'll see you back here next time on Protected Thoughts. Check us out on McBrayerFirm.com.
Thank you, Mary Lise. Goodbye.
Thanks, Bruce. Have a great night. See you next time.